Okay, so what we're going to look at today is Louisiana Purchase and the Constitution. We're really going to look and focus on um, the questions of the constitutionality of making a purchase, of the Congress and the federal government making this purchase, and the power of government, and so how they viewed power of government way back then, so power yesterday and then today. We're gonna take some of those lessons and see and look at how some of that is similar to issues and problems that we have to deal with today. So we're going to talk about the Louisiana Purchase, but mostly really what we're looking at here today is the Constitution. And so you're probably, whoa, look at that slide, Michelle Alexander. That's kind of ridiculous. You don't want us to read all that, do you? Well, no, we don't need to read all of it. You'll notice I've got a couple of sections that are a little bigger and highlighted or bolded, and so you see here this clause right here, and then this last one here at the bottom. And so what we're looking at is two different clauses, but the one we're going to focus on for the Louisiana Purchase is this one at the bottom, which is called the necessary and proper clause often, and it is also called the elastic clause sometimes as well. And so let's, taking off some of these lines here, so let's look, and as you kind of look through, and you'll notice the title says Delegated or Enumerated Powers. This is just a list of powers, and this is the list of powers in the Constitution that the federal government has. It's in Article 1, it's Section 8 of the Constitution, and this is basically saying the powers that the Congress can do. This is the things Congress can do. Here's the list. And you notice there's 18 items. Now within each one of these, some of them have multiple actual powers they can do, so it's not like they only have 18 powers. There's actually more than that. But these are the ones that are listed. There's two, like we said, that I've highlighted, and then let's talk about the necessary and proper clause. We've talked about this a little bit in class, and basically, let's just read it. It says, to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States or any department or officer thereof. And what's that saying? What that is saying is, if it's necessary and proper to make a law to do something, so that you can do all these others that are up here, so you have the right to make that other law. So this is why it's called the necessary and proper. If it's necessary, if you need to do something so that you can do one of these other things that you're supposed to be doing, then it's okay to make this other law, even though we don't have it on the list. The question becomes, how do you define necessary and proper? And that's what we looked at when we talked about the National Bank. Alexander Hamilton and the Federalists, they kind of looked at it as more loosely and interpreted the Constitution more loosely, and so they said, yes, we can have it. We have a national bank. Well, that meant the Jefferson and the Republicans were against it because they didn't want to interpret it more loosely. Well, the Louisiana Purchase kind of falls into that same category. Is it necessary and proper? Well, is it on this list? Does anywhere on here, does it say any of these things? Do any of them say we can purchase land from another country? No, it doesn't. And so how are they going to do that under the Constitution? Is it legal to do that? Well, Jefferson had some qualms about that because he was the one that didn't want a national bank because it doesn't say we can do it, so it doesn't say we can make a purchase. So he kind of felt like we shouldn't. So let's move on and talk a little bit more about real quick, couple of other parts of the Constitution that are going to be helpful here is really Amendment 10 here more than Amendment 9. But these are a couple of amendments that sometimes we don't think about very much, but can be pretty significant when it comes to government power. So Amendment 10 says the power is not delegated, in other words, not listed by the Constitution, nor prohibited by it to the states. In other words, there's other sections where it says the states can't do this, are reserved to the states or to the people. So the states or the people have powers that aren't listed. Anything that's not listed in the Constitution, basically those powers are for the states or the people. That's not for the federal government to do. So then the question becomes, how should we interpret the Constitution? Well, according to the Federalist, we should interpret the Constitution loosely. Government, we need a more powerful government. They're coming from the Articles of Confederation, which is a weak government. We need a more powerful government. And a loose interpretation gives you a more powerful government because it can do more. It is more active. So if you do more things, then you are doing more as a government. So you're a more active government. That means you have more power. And so you interpret the rules more loosely. In other words, you don't say, well, you have to do only exactly what this says you can do. Well, you can do things as long as it's the basic idea, you can do it. So that's a more loose interpretation of the Constitution. It means the government can do more. It means the government has more power. If the Constitution doesn't say we can't do it, and it will help us do one of our enumerated powers, that's what we were talking about earlier, then it is constitutional. And what I just kind of read there, that comes from this idea of the necessary and proper clause. If it will help us. So they kind of interpret the necessary and proper meaning. If it helps us do one of these other things, it's okay. So create a national bank? Well, yes, because it helps us do other things that we're supposed to do. We can collect taxes and put them there. It helps us do that. We can issue currency under the enumerated clause, under these other laws, other parts of the Constitution. So this bank will be the avenue in which we issue the currency, and so it's a good idea. So we can do that. Jefferson and the Republicans said, well, wait a second. We could do these things without creating a national bank, so it's not necessary and proper. And so you see the difference. Hamilton says it helps us to do these things. This is how we'll use this bank, so it's necessary for us to do these things. Well, and Jefferson disagrees. So then it comes to the Louisiana Purchase. It's not on the list. Well, Hamilton doesn't have as big a problem with the purchase of Louisiana from a constitutional issue. Now, he doesn't necessarily think it's a good idea, as we looked in class the other day and looked at some of those documents. He wasn't really in favor of it, but it wasn't so much on constitutional grounds as far as does Congress have the power to make that purchase. He wouldn't have been as concerned about that because he just generally thought the government had a little more freedom of power. There were a few constitutional issues that some Federalists had, but it had to do with forcing the Congress to accept some of the regulations of the treaty. Of course, the Senate had a say in that treaty. They could reject it or accept it. And since they accepted it, that kind of deals with that issue. But that's a rabbit hole we don't need to focus on too much. The other side of the question is, well, how should we interpret the Constitution if you're a Republican? Well, they have a strict interpretation of the Constitution. In other words, government can only do what the Constitution says. In other words, that makes you a less active government. A less active government has less power because you're just doing less. If the Constitution does not clearly state you can do X, in other words, if it's not in that list of enumerated powers, then you have to be certain that it is absolutely necessary and proper for carrying it out. And if you can do those duties that you're supposed to be doing as a government without creating something like a national bank, then it's not constitutional. So creating a national bank you shouldn't do because you can collect taxes without a national bank. You can issue currency without a national bank. And so therefore we shouldn't do it. Much more strict interpretation. So based on that, you would think, well, Louisiana Purchase comes along. Should we be making this purchase? And according to Jefferson's logic on creating a national bank, the answer to this purchase is no. Because it's not in the list of powers that we have, and so therefore we shouldn't do it. How does he get around that? Well, one, he just saw that it was far too important an opportunity to pass up. But the other thing, and he does become more convinced of it, is the government does have the power by treaty to make treaties with other nations. And so this is a treaty. And so he does, not just make up something as an excuse to buy it. He comes up with what is a pretty sound constitutional ground that, well, we can make a treaty with another country, and in that treaty, in this case, the treaty says we're going to purchase this land. And so it's by treaty that we make this purchase. And we do have, the Constitution does give the President and Congress the ability to make treaties. And so, are we going to accept the Louisiana Purchase? The answer, based on the Constitution, is yes. And so there we go. And now, how should we interpret the Constitution is the next question. Should we have a more loose interpretation of the Constitution, where therefore a more active government, or should we have a stricter interpretation of the Constitution and therefore a less active government? And that's kind of a question that we always still have today. So let's look a little bit deeper at some of those issues. And those are issues that we have all the time. Those are there's issues that come up all the time about is this constitutional or not. One example is the Affordable Care Act, also known as Obamacare. The health insurance law, and it's a health insurance law, and the Commerce Clause, we didn't really look at it too much, but the Commerce Clause basically gives the federal government the right to regulate commerce, and commerce is another way of saying trade, especially between states and commerce between states. And so the Affordable Care Act says you must buy health insurance. Well, people say, wait a second, the federal government has never told anybody they had to buy something, and so there was a challenge in saying this isn't constitutional. They don't have the power to say you have to buy something. Well, the administration said we can do this because the Commerce Clause gives us the right and ability to regulate trade. Well, the Supreme Court said, well, you're not regulating trade. This person's choosing to not trade. They're choosing to not purchase insurance. That's not trade. That's the opposite of trade. That's not participating in trade. And so the Supreme Court says you can't force people to participate in commerce based on the Commerce Clause. But wait a second, Mr. Alexander, you said that I know the Affordable Care Act is still an issue, is still being done. So this sounds like they said it was unconstitutional. Well, they didn't agree with the argument of the Commerce Clause. But what they said is you can say, the federal government can say, choosing to not buy insurance is a taxable event. So the Congress can decide, well, we're going to tax people for not buying insurance. And so according to the Supreme Court, now they didn't all agree. It was actually a 5-4 decision. So there's a lot of question about this. But the basic idea is you can choose, what they said is, you can choose to put a tax on people that are refusing to buy or not buying insurance. So you're not saying you have to buy insurance. You're just saying if you don't buy insurance, that's taxable. We can tax you for not doing something. And so what does this mean? Well, these kinds of issues, this is why picking a new Supreme Court justice can be such a big argument. Because the question becomes, well, how will they interpret the Constitution? Will they be more like a Federalist and interpret it loosely? Or will they be more like a Republican of the Jefferson time period and interpret it more strictly? And so we have these questions still today, and we still argue and fight about them, just like Jefferson and Hamilton did a long time ago, we do today. And so we sometimes think, well, people are just so rude to each other and everything, and our society is not very civil. But you know what? Jefferson and Hamilton and their groups weren't very nice to each other back then, and if we could get through those times back then, maybe we can get through these times today. Of course, it's better when we treat each other well, but remember that for a long time people have been getting very upset about politics and the Constitution and what it really means. So that's it. That's Louisiana Purchase and our Constitution.